Hello everyone. So we are back with our next session of revision, and in this video we are going to discuss the unpaid seller, the last unit of Sale of Goods Act, which is about unpaid seller. So who is an unpaid seller who has not received the whole price of the goods? So I am saying not received the whole price. That means even if he has received the part price, is he an unpaid seller? Yes. Why he did not receive? Because the buyer did not pay. Is it that the buyer is not supposed to pay, or the buyer must pay and he did not pay? The buyer must pay and he did not pay. So if there is a credit period, during the credit period, I'm not an unpaid seller. But after the credit period, if I don't get my money, I become an unpaid seller. Now, why has he not received the money? There was no credit period, but the buyer did not pay. There was a credit period which has expired, but the buyer did not pay. Payment was made by a negotiable instrument and the same has been dishonored, or the buyer has become insolvent. In all of these four cases, the buyer is an unpaid seller. The seller is an unpaid seller. Now, this unpaid seller has both rights over the goods and against the buyer. Rights over the goods, he has three rights: rights of lien, stoppage, and right to resell. Lien means what? To retain the possession. I have the goods, I'll keep the goods. Simple. I have sold the goods, but I still have the goods and I become unpaid. Why I become unpaid? Any of the four reasons. We just discussed the four reasons. Any of the four reasons. I can keep the goods with me and not deliver them to the buyer. This is rights of lien. Now the question is, when does the lien come to an end? It comes to an end means what? Now please understand, when I say comes to an end, does it mean it cannot be exercised, or it's exercised and comes to an end? It cannot be exercised. When I've sent the goods to the carrier for delivery to the buyer, it's to an end because I don't have the goods. For lien, I must have the goods. Second, when the buyer tenders the payment, that is, the buyer offers to pay or he pays. Now, I am keeping the goods because you did not pay. Now, if you're offering to pay, how can I keep the goods? Or the buyer or his agent lawfully acquire the goods. They have the court order, they show the court order to get the goods, or the buyer, or by estoppel or waiver. Estoppel, in front of everyone, the seller tells the buyer, I will never stop the goods. Whenever you ask, I'll give. So he makes everyone believe that he doesn't have the rights of estoppel. Waive means to give up. I'm supposed to receive the money today. If you don't pay me today, from tomorrow, I have a right of lien. You come and say, ma'am, please give me extension. I say, yeah, go take extension. I have given up my rights of lien till the period of extension. Rights of stoppage in transit. When I say rights of stoppage in transit, the goods are in transit. They are neither with the seller nor with the buyer. They are in transit and the buyer has become insolvent. And so the seller has become an unpaid seller. He can stop the goods. That is, he can call the carrier and say, keep the goods wherever they are. Or he can say, please bring the goods back to me. This is how he exercises stoppage in transit. When does stoppage come to an end? The moment goods reach the buyer. Now, if the goods are collected before the delivery point, the place where the goods are collected, the delivery comes to an end. If the buyer's agent takes the goods, the delivery comes to an end as soon as the buyer's agent takes the goods. If the goods are supposed to be delivered at one point, but the buyer asks the carrier to deliver it forward, further ahead, the delivery comes to an end the moment he acknowledges that the goods are to be delivered at a further point. That means at the point of delivery only. After all this, if he does not get his money, can he also resell the goods? Yes. What will I do keeping the goods? He may also resell the goods. But the goods do not belong to me. So before I resell the goods, I must give a notice to the buyer and wait for a reasonable period of time. If during this period the buyer pays fine, if he doesn't, then I can resell the goods. If I have given him a notice and he still did not pay me the price, it's his fault. So if on resale I have a loss, I'll recover that loss from him. But if there is a profit, I can keep the profit. But if I don't give him a notice, it's my fault. So if there is a loss, I will bear it. But if there is a profit, I have to give it to the buyer because I'm just acting as an agent for him. On the other hand, if the goods are perishable, I cannot give a notice there. So it's deemed that the notice was given. Now, what are the rights against the buyer? He has a right to sue for the price. I've not received the price, I'll sue for the price. He has a right to sue for interest for delayed payment. Even if the agreement does not say about interest, he still has a right to claim the interest. The seller is ready to deliver the goods but the buyer is not taking the possession of the goods. He has a right to sue for damages for non-acceptance of goods. And if there is a breach, obviously all this is breach only, he can sue for breach of contract. If it's actual breach, both price and damages. If it's anticipatory breach, only for the damages. Now, what happens if the goods are sold to the buyer, but the seller has, and the buyer resells the goods, but the goods are still with the seller and he becomes unpaid? Can he still exercise rights? Yes. Any subsale or pledge made by the buyer does not affect the rights of an unpaid seller over the goods. That means if he has the goods, he can exercise his rights over the goods. But in case, but in case he has only given, the seller told the buyer or gave his consent to the buyer for the subsale or pledge, then how can he stop the goods? Or the buyer has the document of title which he transferred to the new buyer. Then in that case, he cannot exercise any rights over the goods. Otherwise, he can exercise rights over the goods. The next one, we've been talking about the seller breaching. Even the buyer can breach. So what happens if the buyer breaches the contract? First of all, if the seller, we have been talking buyer breaches. What happens if the seller breaches the contract? The buyer is ready to take the delivery, but the seller is not in a position to deliver. Can the buyer sue the seller for damages for non-delivery of goods? Yes. If the goods have no substitute or damages are not an adequate relief, he can also sue for specific performance. If there is a breach of warranty or there's a breach of condition which is treated as a breach of warranty, he can sue for damages. Or if there is a breach of condition or he has paid advance money, but the seller does not give him the seller does not give him the goods, he can ask for the refund of the price. The last topic, auction sale. It's an invitation to offer. Sale is complete on the fall of the hammer. Before the fall of the hammer, can I retract my bid? Yes. The sale may be subject to a reserve or upset price. In that case, the sale will be made only at that price or above, never below. So if the auction will start at that price or the auction should reach that price. Otherwise, I'm not bound to sell. Um, Goods can be put up in lots and every lot is a separate contract. The seller, if he wants to bid at the auction, he can bid or he can send his agent to bid at the auction, but he has to reserve the rights to bid. If he bids without reserving the rights, it's fraud and the contract is voidable. If the seller appoints more than one bidder, why would he appoint more than one bidder? For pretended bidding. The sale is voidable at the option of the buyer. We have covered everything. So I hope you are studying well. Happy learning and stay motivated. Thank you so much.